Good afternoon, everyone. Hope everybody's having a good day so far. I see we have about 27 attendees on the call, but to be respectful of all your times, we want to make sure we start on time today. So I'll go ahead and get this started. My name is Bashirat Osunmakinde. I'm the Senior Director of Care at the AIDS Foundation of Chicago. The webinar today is surrounding the topic, Attack on Immigrants or Immigration. We'll be specifically talking about the expected changes to the public charge. So I want to start by saying thank you all. I know it's a Friday, and I know the weather is really nice outside, but thank you for joining us today for this very important discussion we'll be having. We are joined here today by our two presenters. So Carrie is here from Legal Counsel for Health Justice, and Luvia from Illinois Coalition of Immigrant Refugee Rights. So those will be the presenters for today. I am going to go ahead and move this on to Elena. She'll be talking about some of the logistics for the webinar.
Hi, my name is Elena Kennedy. I work here at AIDS Foundation of Chicago. On your right-hand side, you can see a panel where you can ask questions. We will have a question and answer period towards the end of the webinar after the discussion. So please input any questions you may have. If we don't get to you during the webinar, we will try to do our best to answer all questions at the end or try to answer any questions afterwards. We will also be producing a survey that will go out to everyone who signed up, even those who did not attend and are choosing to listen to this after the fact on listen-only mode. And you can ask any questions at that point as well. Just as a reminder, everyone is on listen-only mode except for the presenters and our moderator today. So once again, please input any questions on the side panel. Thank you so much.
Thank you, Elena. So to get us started, we're going to start with some poll questions. I'll go ahead and read out the poll questions, and we'll give you some time to select your or the appropriate answer, and then we'll have a quick discussion after each poll question. There are 3 poll questions that are going to come up on your screen now. The very first one being, what is your knowledge or comfort level with the information related to the public charge issue? So please take a few seconds to answer that question. Great, thank you all for doing that. So the results show about 70% of the respondents feel either slightly comfortable or not very comfortable with this topic. So I'm really glad we're having this webinar today, and hopefully we can increase your comfort level by the end of the hour session. We're going to go ahead and move on to the second poll question. And this question is, of the clients you work with, what percentage would possibly be impacted by this change? Again, please take a few seconds to answer that question. Great, thank you. So the results here show that about 48% of you feel like about 6 to 20% of your clients would be affected, and about 24% felt like 21 to 50% would be affected. Regardless of these percentages, I mean, these are, lives we're talking about. So based on those numbers, again, this webinar is great because it will give you a lot of information to talk to the clients on your caseload and better prepare them on any policy changes. We'll move on to the third poll question. So the question is, do you believe that this rule change will affect the way clients use healthcare and social services? Great. So the results are out, and looks like about 80% of the folks on the call mostly agree that this will affect access to healthcare services, and about 30% completely agreed with that. So obviously, within the field that we're working with, I mean, healthcare access is the goal, and making sure our clients are getting linked to care and getting access to their medication. So this is really problematic. Thank you all for taking the time to answer those 3 questions. We will then go ahead and move right along to the presenters. So without further ado, I'd like to introduce both Carrie and Luvia.
Hi, so I'm going to kick it off. This is Carrie. Again, I work at the Legal Council for Health Justice, and I'm here with Luvia from ICER. And we're both a part of the Protecting Immigrant Families Illinois Coalition, which is a statewide coalition of advocates, service providers, community organizations, and immigrants working to ensure safe access to the safety net for everybody. And at the end of the presentation, we'll talk about the ways you can join PIF Illinois and just get additional information on public charge as it comes out, so you can sort of be at the cutting edge of getting information on this issue. So I'm just going to briefly introduce the goals of the webinar and then turn it over to Luvia to talk a little bit about what public charge is. It's certainly a concept that has not been very used much up until this moment, and so please don't feel surprised that you haven't heard much about it or have only heard it mentioned briefly, because it's sort of an obscure little doctrine that's now seeing the light of day in the current administration. So our goals of the webinar overall are to understand the public charge doctrine. We're going to explain to you the timeline of leaked drafts of this new rule, what we expect the new rule to look like when it's actually published, the process for federal rulemaking, and how you can comment and get involved, and also what we might want to start saying to our patient clients about this issue. So over the past year, we've been hearing rumors that the Trump administration was planning to restrict immigration by changing and making more harsh a fairly little known doctrine called public charge. And while rumors have been circulating for more than a year, it looks like the proposed rule is finally moving forward. So we saw 2 leaked drafts, one in February and one in March of this year. And so from leaked drafts, we never know if that's going to turn into an actual proposed rule, but the rule has now been sent to the Office of Management and Budget, which is the first step in an official federal rulemaking process. So we know that this is now happening. We expect the rule to come out of OMB, the Office of Management and Budget, and be published in the Federal Register anytime. So it could happen tomorrow, it could happen in 2 weeks, it could happen in 6 weeks. And once it comes out of the Office of Management and Budget and is published in the Federal Register, we will have an opportunity as a country to comment on the rule. We'll either have 30 or 60 days, and I'll explain more about that later. And it will be a really important time for us to talk about our concerns about the rule. So right now, nothing has changed about the way that public charge is operating within the continental United States. So there has not been a new rule, and the way that public charge is being implemented within the U.S. is the same it has always been, and Luvia will explain that that is very limited and narrow. However, there has been a change in the policy at consular offices throughout the world. So some folks who are trying to get a green card are in the United States and go through a process of adjustment here in the U.S. to get that green card. But many, many people, particularly people who are being sponsored by family members, are in their country of origin and seek to adjust from their country of origin. And so they seek their green cards through the U.S. consulate in their country. And the policy at U.S. consulates, all of them, has changed, and they are asking more questions and asking for more information about public charge in those consular offices right now. They've already started it. And in particular, in the consular office in Ciudad Juarez, we are seeing a lot of people who are not being able to adjust because they're being asked a lot of questions about public charge. So for a while we were sort of saying this might be coming down the pike and we should watch for it, now that the rule is at OMB and that the consular offices are changing their behavior, it's probably time for us to start talking with community and answering community's questions about the rule. So I'm going to turn it over to Luvia to talk about the current public charge test, and we'll go from there.
Hi, everyone. So I'm going to share briefly right now, so as of today, so this could change tomorrow or later on, but as of today, kind of this idea, this concept, or what we've been calling recently, this public charge test. We know that public charge as a concept is a little, you could say, difficult to understand, let alone to explain to your clients. So we're going to try to simplify it as much as possible. Public charge is a concept that has been around for over 100 years. I believe it dates to like the 1880s, and it's currently part of federal immigration statute. This statute allows federal immigration officials to deny admission to the United States or denied adjustment to legal permanent residents, also known as LPRs or green card holders. If the immigration official deems that a person is likely to become a public charge, meaning this person might at one point or another end up relying on government assistance of some sort, which we'll explain briefly. The current public charge analysis is generally triggered by the use of cash assistance, whether it be TANF, SSI, or GA, general assistance, or institutionalization in a long-term care facility for which Medicaid is paying by the immigrant, which, as we all know, is unlikely to be eligible, or the immigrant's child, but only if this income is the parent's only source of financial support and only after looking at the totality of a person's circumstances. Immigration officials are also required to look at other things, such as the immigrant's age, income, assets, skills, education, employment, family status. So again, it's not only the use of possibly those two benefits, but they also need to look at everything else that I just mentioned. This is currently the current public charge test, again, as of today. It has ensured that everyone can receive essential services such as health and nutrition benefits or housing assistance without being considered a public charge on that basis. Next slide. So who is currently subject to the public charge test? It was mentioned briefly by Carrie. So people who live abroad and are seeking to come to the U.S. with some type of visa, or people who are seeking to become legal permanent residents, whether it be adjusting their status here in the United States or having to apply for a waiver and go outside of the United States. It is very important that everyone understands who this may affect and who it does not affect. So you'll see on your on the slide right now a list of some of these. I will say that we tried our best to include most of the individuals that are not subject to the public charge test, but there might be a few categories that we omitted, mainly because the list is pretty long, as you can see. So for those of you that might be working with some of these individuals, so let's say that you're working with a refugee, for example, please assure them that no matter what happens in the future, they will not be, this will not affect them. That's just one example. Again, you'll see from the list that it's pretty exhaustive. In addition to these categories, public charge is not a factor considered in naturalization applications. That is for individuals that are legal permanent residents applying for U.S. citizenship do not undergo the public charge test. These exclusions to the public charge test are encoded in law and cannot be changed unilaterally by the Trump administration by their executive or administrative power. So the last few slides have shown you that the current public charge test is and which immigrant statuses it applies to, and which immigrant categories are not subject to the test. This is the current and long-standing interpretation of the public charge rules. The next slide is going to show us some of the proposed changes to this long-standing rule according to the leaked draft that Carrie mentioned earlier. Remember that because the official proposed rule has not yet been filed in the Federal Register, we do not know for sure what changes will actually be proposed by the Trump administration. We are using the two leaked drafts as proxy for those expected changes, but even among those leaked drafts, there have been some differences. Please keep this in mind as we discuss the next slide.
So it's Carrie again. So the leaked draft that was published at the end of March in the Washington Post shows that the Trump administration plans to dramatically expand the type of benefits and programs that an immigration official would consider in making the public charge determination. So immigration officials would be required to look at whether the immigrant being reviewed or any of their dependent family members, which includes but isn't limited to their U.S. citizen children, have received or applied for any of the benefits listed on this slide and possibly others. So the first two bullets on this slide show you the programs that are considered in the current public charge test, so cash assistance, TANF, SSI, and GA, which we don't have in Cook County anymore, but that there is in townships throughout Illinois. So if your family is receiving TANF cash or SSI cash, and that is the only income coming into the immigrant's family, then they are allowed to be subject to the public charge test when they go to adjust. Or if they are institutionalized at government expense, so generally at Medicaid expense. That's not a huge issue in Illinois because in general we don't provide nursing home care through Medicaid for people without documentation, but there are a number of states like California that do. And so it would, those individuals are currently subject to a public charge test. But the programs and benefits listed in red show the really quite dramatic expansion in the types of benefits to be included in the new public charge test. So things like SNAP, health insurance, any kind of Medicaid, traditional Medicaid, all kids, the tax credits, so the earned income tax credits and potentially the premium tax credits on the marketplace, LIHEAP benefits, and housing assistance, housing vouchers, and public housing. So the test would remain, under the leaked draft proposed rules, the test would remain a totality of the circumstances test, so it wouldn't just be your or your dependent's use of benefits that would be considered in whether or not you would be permitted to adjust. They would look at other things in your life as well, but these would be sort of strong negative factors, meaning they would weigh heavily against your ability to adjust. And they could be used by the decision maker to say, nope, you are going to become a public charge as a result of your or your dependent's use of these benefits, so you may not get a green card. Disturbingly, other factors would also be strongly weighted negative factors, and I think the one that affects probably most of the folks on the phone is chronic disease. So chronic disease in and of itself would be considered a strongly negative factor, which would be weighed against you as you seek to adjust. And so the combination of a chronic illness and use of benefits, particularly if you are at or below 250% of the poverty level, would likely make it very difficult for you to adjust status. So there are benefits that are excluded from consideration. They tend to be benefits connected to work or military service. Emergency and disaster assistance are excluded. Certain government student loans, if your child took government student loans, they would be exempted. But the kind of traditional benefits that we think of applying people for in human services would be included. And we just want to, next slide. We just want to highlight that one of our big concerns about this is that the new test specifically highlights the application for or use of these basic needs programs by the applicant's dependents, including their U.S. citizen children. So as you guys know, a lot of times our clients are eligible for some benefits but not eligible for others. Our immigrant clients may have a lot of benefits they're not eligible for, but many of them live in blended families and they have U.S. citizen children. And so the new rule would say that the children's use of a benefit, for example, such as Medicaid, would be a strongly weighted negative factor against the parent if the parent went to adjust to become an LPR. And obviously, this is just a really upsetting policy change, but it fits in with this administration's intention to really limit family immigration. This has been an explicit goal of theirs. I'm not telling tales out of school. They really want to limit family immigration, and this is one of the ways that they're hoping to do that. So we've been a little bit grim about this situation, and it is in fact, you know, a serious and concerning plan by the administration. But there are some things that we can do about it, and one of the things that we can do is we can understand the federal rulemaking process, because we have an opportunity, each and every one of us, and our institutions and organizations have an opportunity to speak our mind about these proposed rules. So there's basically a regulatory timeline for changing a federal rule. The proposed rule has to be filed in the Federal Register, and then the comment period on the rule opens. The agency promulgating the rule, in this case, DHS, the Department of Homeland Security, decides whether we have 30 days or 60 days to comment. In the draft rules, they had a 60-day comment period, and I remain hopeful that they would stick with that. But the truth is, if they wanted to be nasty, they would make it 30 days, and so it could only be 30 days. And during that comment period, any one of us can submit comments through a portal, an electronic portal, a website, called at regulations.gov. And so one of the things that we are working with the National Protecting Immigrant Families Coalition and the Protecting Immigrant Families Illinois Coalition to do is to, first of all, alert everybody when the proposed rule is published in the Federal Register, but also to circulate templates for comments so that you're not writing comments out of the blue. And also, the National PIF campaign is looking to develop a microsite where you can go to the microsite, not to regulations.gov, and use templates and just personalize them a little bit, and then that site will submit the comments to regulations.gov. So we are going to share template comments and an easy way to submit comments. And what we're really hoping to do is to drive up as many comments as possible on the rule. Now, I'm going to be honest about the significance of commenting on a federal rule. It's not a vote, right? So it's not like if we submit 100,000 comments, which is our goal nationwide, that they have to stop the rule. Over 100,000 and they have to pull back the rule. That's not how it works, sadly. But there are really important benefits to commenting. So first of all, it draws a lot of attention to the rule. So a lot of media attention will be paid to the rule the higher the number of comments are. And the more people we get educated about how ridiculous this policy is and how punitive it is and really its harm to public health, then we may be able to generate increased opposition to it. And so it's important for us to sort of make a show of strength. And so the National PIF campaign coalition is trying to drive 100,000 comments. And if that seems like a lot, there was a proposed rule about tips that you guys may have heard of briefly in the news, where essentially the administration wanted to take tips away from servers in this country and give them to employers. And they got 200,000 comments. So it is perfectly possible to generate a lot, and it's a huge show of force. And so it's significant. It's also true that they have to review and to a degree address the comments. They don't have to change the rule, but they have to sort of explain why the comment is invalid. And that's time consuming for them, and it's also sort of an embarrassing process for them. The comments all become a matter of public record. So if we want to change this rule, if the administration changes, we can show this was a bad idea from the very beginning. Hundreds of thousands of people opposed it, and we want to go back to the way it was. And then finally, it is possible to litigate this rule if it becomes finalized in certain ways, and sometimes the comments can be helpful in that litigation, can show the harm that the rule causes, and that it wasn't very carefully considered, the impact of the rule wasn't carefully considered, and it might help with litigation. So we are hoping that people will get over whatever nervousness they might have about submitting comments and stay engaged with us, and when the rule is published, comment. After the comment period ends, the agency reviews the comments and then publishes a final rule. And when that final rule is published, shortly thereafter, it essentially is the law of the land. So it's not a statute, but federal regulations are indeed the law of the land. I do think that the rule, the final rule, could end up being litigated, but I want to be honest with folks that if you've heard about, for example, the litigation against the Muslim ban, and that they got a nationwide injunction, meaning bar, against the administration from implementing that rule, I don't think that's what's going to happen here. I don't think that we have the legal hook to get a nationwide injunction against the rule. And so that actually makes comments even more important, because if we can't win this battle just by litigation, then the show of force is really, really key. Yeah. Okay. So what can you do, and how does this affect people? So obviously, you can join either or both the PIF Illinois and the National PIF Protecting Immigrant Families Coalitions, and you will get updates all the time. You can gear up to make comments, get ready, get informed. How are you going to comment on the rules? And then it's probably time to start thinking about how we're talking to the immigrant and immigrant families that we're serving. So I think one of the most important things that we can do right now is to be clear about who is exempted from the rule. So going back to that big list of statuses that Luvia went over, and really kind of getting familiar with that list and talking to immigrants about what type of status that they have, and if they are on the exempted list, helping them understand that public charge will not be a test that's applied to them when they adjust. And so just helping to dispel the fear that the administration is trying to generate by making this rule seem very draconian and scary, by saying to people, actually, all these people are exempt, and you are in one of those statuses. So figuring out if you're talking to a refugee, asylee, a Cuban or Haitian immigrant, somebody with a U visa, somebody with VAWA, and say, you are not subject to this rule. You don't have to be afraid. I will say that there is one slight wrinkle to that, which is that if that individual would later becomes an LPR and later seeks to bring over a family member, it is possible, and so they're the sponsor of a future family member, it is possible that their use of benefits could affect that family member's ability to adjust. But I think in most cases when you talk to your clients about that, if that is a very tenuous future possibility, that should be weighed against the value of the benefit now. So you cannot be subject to public charge. The benefit has a lot of value for you. If you don't have a very tangible plan to become an LPR yourself and then bring over family members, then the value of the benefit right now is probably pretty strong. So it's obviously an individual's decision about how much risk they want to take, but I think it's helpful to say, as you balance the risks, if you don't have a specific sort of vision for getting your family members into the U.S. And you are not subject to the test, then the value of the benefits probably outweighs this like future nebulous possibility down the road. So figuring out who's exempted and talking to them about it is incredibly important. It's also important to say to folks that this rule can't be applied retroactively in all likelihood. So the leaked drafts have said it's not applied retroactively, so it can't be applied before the rule became final. And I think we could litigate retroactivity if they decided to try to be cute and put it in the final rule. It's always possible that they could. I don't think they would, because I don't think they want to draw that kind of litigation. So having benefits right now probably doesn't pose a risk at all, even if you're a person who might be subject to a public charge test, because your current use of benefits before there's even a publication of the rule can't be a part of the test. So I would say that even people who might want to think about disenrolling from benefits once this becomes the law of the land, if it does, unfortunately, certainly don't need to be doing that now. I don't see any benefit to disenrolling now. And so to just encourage people, you know, in general, our laws are not applied backwards before they're passed. That's a concept in U.S. law that's very, very strong. And we don't expect that to happen here. And if it did, we would fight it tooth and nail. So I think that's an important thing to say. And then the other thing I think it's probably important to say to individuals who are dealing with chronic illness is that the truth of the matter is that chronic illness is already a heavily weighted negative factor. And so the truth of the matter is it may not make that much of a difference whether they use benefits or not, because the chronic condition is in and of itself a problem. And there's nothing they can do about the chronic condition, right? And so I think that in terms of doing the cost-benefit analysis, helping people understand, you know, the administration is trying to be nasty, and they're going to take your, you know, chronic diabetes and use it against you anyway. So think about the value of the benefit of medical care when you know that no matter what, they're going to use that against you. And so I think that's something helpful to think about, is to understand that this is a balancing of many factors test, and it's, the administration has listed many things that are negative factors, not just public benefits. And so people need to think aloud. And then also, if somebody is currently using benefits and has no path towards adjustment currently, so there's really no way for them to get status in the current environment. So they could, you know, tomorrow they could be the victim of a crime and potentially be eligible for a U visa, but there's no clear path. They don't have a U.S. citizen child that might help them adjust later. They don't have a family member who is sponsoring them on a temporary visa. There's no clear path for them. That, you know, we do not see a lot of hope in the short term that we're going to get nationwide immigration reform. And so they need to think about using a benefit that's really valuable to them now, weighed against, you know, is there any chance that there's really going to be a path for me in the near future? And so again, it's an individual decision, but at least helping people to understand, if I don't have a path to adjust, if there's really nothing for me, then I need to think about whether I'm ever going to be subject to this test. If I'm never going to adjust, I'm never going to be subject to the test. Or if it's very unlikely I'm going to adjust, and then what are the benefits of taking Medicaid or the other benefit now to me in the present? And so I think that's also helpful for people to understand. The folks who are, I think, the most at risk are folks who it is a high priority for them to adjust. So they've got a sponsor and they've got some kind of lawful presence here, and they're going to try to become an LPR soon. Or people who have a very clear, definite, short-term plan to get family members here to the U.S. I think for those individuals, this is a more nuanced discussion, and I would say that probably those folks, we need to get connected with a lawyer. At this early stage in the process, when we don't exactly know how this, now, not right now, again, nothing's happening now, but once there's a rule, I think we're going to need to send folks who are either pretty close to that, you know, I'm going to go for my green card interview, or these are my family members who live in other countries and I have a very specific plan to bring them here. Those are folks that are going to need individual counseling and I think probably legal advice at the beginning. But again, that's actually a fairly small universe of people, right? If you exclude everybody who the law excludes, refugees, asylees, Cuban, Haitian interns, all of those folks, if you generally advise but exclude the folks who don't have a pathway to adjustment, and it's a fairly simple, you know, if you don't see a pathway, think about the value of the benefit. People who are going to have many negative factors anyway, they're low income, they're chronically ill, age is considered a factor, so they're older, employment is considered a factor, maybe they're not employed, that this is just one of many factors, and if they have many heavily weighted negative factors, it just may not be worth it to give up the Medicaid. Just to repeat, who may need to go to a lawyer? So first of all, nobody needs to go to a lawyer now, although I'm happy and Luvia is happy to respond to questions now as you get them, but in terms of who needs to sit down with a lawyer now, probably nobody. I mean, you may need an immigration lawyer, don't get me wrong, but about public charge, it's not even a published rule. So, and it can't be applied retroactively. So nobody needs a lawyer now. Once this becomes a final rule and is the law of the land, then the folks who I think are going to need counsel are folks who are either themselves about to adjust, so they're in the process of getting their green card and they haven't had that final interview, and they or their children are using benefits. Those folks will need counsel, and people who have a very concrete plan to bring over family members, like I know who they are, and this is my timeline, and this is the pathway we're using, but I or my children are on benefits now. I think those folks are going to want to seek the benefit of counsel. And obviously, if this rule is enacted, the lawyers among us will try, particularly those who are practicing in immigration, will try very hard to learn as quickly as we can about how the Department of Homeland Security and USCIS are interpreting these in those meetings, and figure out what the real risk is for people. And another group, again, that's excluded are people who already are LPRs and want to naturalize. It's not part of the naturalization analysis. Now, there's a couple wrinkles to that are really wonky, and I'm not going to go into, but it is not a part of the naturalization process. So folks who already have a green card and are using benefits cannot be subject to the public charge test in their naturalization process because it doesn't exist there. It's not a test that's operative there. It is possible they will do something really outrageous about deportability on public charge, but we haven't seen any leaked language about that, and I'm not going to go there because, frankly, yeah, there's a placeholder for it, but there's not leaked language about it, and the truth is we're just going to have to deal with that if it comes. But it's terrifying to people to speculate about deportability on public charge grounds, and so I would recommend that nobody mentions that now in community because it's just terrifying and we don't have any information. Like, we do have leaked language about the rest of the rule. We don't have anything about this portion of the rule, and then we'll just become agents of the administration and spreading fear. So I really would encourage you not to talk about that. And the minute we have something, if we get something about deportability, I promise that we will be right out there at every chance we have saying this is exactly what they're trying to do. So, Luvia, do you have things you want to add on public communication?
No, one of the things that we've been telling many of our members who deal with clients, patients, et cetera, is how Carrie mentioned, making sure that everyone's aware of who this may apply to and who's exempt. So making really sure that each of you that are working with clients on a daily basis are familiar with that. And two, one thing that we've also been telling many of our community members is to really think about their own individual case. So in the example, for example, where an individual is undocumented, has no immediate relative, so therefore has no pathway to get a green card, then does it really matter that he or she, let's say that's a woman, and she has a child, if she has a child and she ends up taking advantage of moms and babies here in the state of Illinois, does it really matter that she's taking that benefit when her only pathway to get a green card is 21 years down the line after the baby turns 21? Does it really matter? So I don't think that's something for each of you that are attending this webinar, need to make that decision, but just know that even if this does get filed in the next day or few weeks, that there could be exceptions, there could be different circumstances depending on the individual.
And 21 years is a very long time. You could be on Medicaid for a couple of years, go to adjust 20 years later. I mean, who knows, right? The world could be a completely different place in 20 years, and so it's a very far time horizon to be doing something like not taking insurance that you need to have a safe delivery or not taking insurance that your child needs to be healthy. And again, people need to make their own choices, but I think helping people really have a moment of calm. You know, I was listening to something this morning about the Poison Control Center, and talking about how great it is and how people call in a panic because they or their child oftentimes has taken some kind of poison and they're in a panic. And the role of the Poison Control Center is really to just be very factual and calm and clear. And I thought that's exactly what we really need on public charge, is people to be very calm, like, I'm not worked up about this, I'm calm about this, I'm going to ask you all of the sort of relevant questions, like, are you a refugee or asylee? You know, who might you want to bring from another place? I'm going to be very factual and calm. in the hopes that you will be able to get to a place where you're making a rational decision. And that is part of how we sort of fight for our country, right? Is that we help people make rational decisions and we don't let fear take over, because once fear spreads, it becomes really damaging for all of us, and that damage is much harder to recover from. And so to help people get back to a place where they're like, okay, this isn't awesome, and I'm not happy that this is the rule, but I know, I understand it, and I know what its implications are, and I can make a decision about what to do.
The only other part that I would add is, I know that I believe you have in front of you the email that you could sign up for to get involved. But know that each of us, with your help of collecting stories, etc., we are going to be resisting, we are going to be advocating, and we are going to be fighting against it. We are going to need your help in getting those stories and making sure that we're submitting as many comments as possible. But please know that even if this does become effective, we are going to be fighting against it in a variety of ways. Oh, yes, and one thing that we wanted to share, it's related to this, so it's not too off topic, but one thing, given the topic that I know it's a little, besides infuriating, sad of this proposal, wanted to share some good news as of yesterday. So this again is Luvia with ICER in partnership with many of our members. We're proposing a couple of different bills in Springfield, all of them pro-immigrant, and one of them is called Safe Zones, SB 35. I'm happy to say, first of all, that all three passed out, so they're now on their way to the governor's office. And Safe Zones specifically, I wanted to highlight because it does two main things. One is the Attorney General is going to be working with libraries, hospitals, and other health institutions, courthouses, as well as schools, to make sure that they develop model policies in creating welcoming environments for everyone. And secondly, very important is for each of these institutions to stop collecting any information that may show the status of the individual. So just wanted to share that with everyone.
Great. Thank you so much for that information. I feel like every time I listen to this presentation, I learn a little bit more each and every time. So thank you so much for taking the time for this. Okay, folks, let's move on to our final poll question. So this question is regarding your knowledge and comfort level with the information related to the public charge issue after that presentation. Great. Thank you all for all your responses. It shows about 80% of folks on the call either being moderately comfortable or very comfortable. There's obviously more work to do with this, more information coming, and more learning opportunities on this topic. But again, I want to thank you all for participating, and I want to thank the presenters for the great information that they have provided as well. I would like to then open up the call or the webinar today and discuss some of the questions you all may have. We have obviously experts here in the room that are able to answer or your question or dig a little bit more to find responses. Okay, so one question has come in, and that first question is, the case manager wants a clarification. If an immigrant's U.S. citizen child is of age, 18 and over, and receives assistance such as SNAP or Medicaid, will that still affect the immigrant parents? Let's just say that the parent didn't use any public aid when the child was a minor.
So the question is really not your relationship to the person, it's whether, like biological relationship or adoptive relationship, it's whether they are your dependent. And so if that 18-year-old lives in your house and you provide them with shelter and you claim them on taxes, then they are your dependent and their use of benefits would count. And the same thing would be true of other family members in your house who you claim as your dependent and who you provide support for. So unfortunately, just reaching majority doesn't solve the problem. And if you had, for example, your mother living in your house and she became eligible for benefits, but you listed her on your taxes and she was your dependent, then that would be a public charge issue for you.
Great. Thank you so much for that response. A few other questions have come in. So if this would go through, how would it impact clients who are under ADAP? Would clients be discouraged to utilize the MAP/PAP services?
So this is tricky. Ryan White and ADAP and other programs are not listed in the leaked proposed draft proposed rule. On the other hand, so they are not among the listed programs that are definitely going to be considered. On the other hand, the definition of public benefits, all of which are considered in the public charge test, is very broad. It's a very, very broad definition, and it covers federal benefits, and it covers fully state-funded benefits, and it's not just cash benefits. And so while I'm not going to try to make the legal arguments for why ADAP and Ryan White would be included in a public charge test, I think that USCIS could say under the very broad definition of public benefits that they are. So I'm not going to shout that from the rooftops and draw any attention to it, but as a practical matter, that definition of public benefits that triggers the test is clearly broad enough to encompass Ryan White, ADAP, and everything else.
Thank you for that response. Another question. So how does this rule potentially affect patients, clients, or recipients who are recipients of DACA?
Well, currently DACA youth are ineligible in most cases for many of these services. I mean, there are some states, California being one of them, where DACA youth are eligible for Medicaid. Here in the state of Illinois, once they hit the age of 19, DACA youth, Deferred Action for Childhood Arrivals, they're not eligible for Medicaid. If they've used other benefits that they may be eligible for, whether it be moms and babies, is one example, then it could affect them if, again, only if they have a pathway to get a green card. Many of them don't. So again, I don't know how likely it will be for DACA youth to be affected by this. Again, only if they have a pathway in the future.
So really, this unfortunate thing about DACA youth right now, because we weren't able to get enough votes in the House to change this, is that they don't actually have a pathway to citizenship, that they sort of have deferred action, like deferred deportation. They don't have status, and they don't, DACA doesn't give them a pathway to adjusting to become an LPR and eventually a citizen. So they may have other paths. It's not that they can't have a path, it's that DACA is not a path to status. And so they're ineligible for a lot of benefits that they're eligible for when they went, if they got a path to becoming an LPR, those benefits would count and trigger a public charge test for them.
Thank you. Another question, how would immigration know if you have a chronic condition such as HIV? Do they ask directly about health conditions?
Yeah, so this is the nasty part, and this is what's happening in consular offices, which is why it's so concerning, is that when you go to adjust, they have forms that you have to fill out, and you have to fill out those forms truthfully under penalty of perjury, and they have started asking at consular offices, they haven't changed the forms, but they've started asking about things like your health conditions at consular offices. They've said in the draft leaked proposed rules that they're going to change their forms, which indicates that they're going to ask questions more directly. And the rule talks about the right of USCIS to get your medical records. And so the problem is that it really doesn't matter whether the state, for example, divulges that you were on Medicaid, because you as the person adjusting are going to probably be asked a direct question under penalty of perjury, and also, obviously if you lie, then that's grounds for deportation. And so it's not going to be something that you're going to be able to hide.
And traditionally, I mean, ever since I don't know how long, you've always had to have a medical exam when you're adjusting your status. So even if in the scenario that you decide to lie, some of those illnesses may show up in the medical exam as well.
Thank you. So another question. So you talked about the folks that would be affected and those that definitely would not be affected. So what if a client has got married to a U.S. citizen and has their green card at this point, but the green card is conditional? Would that affect the client if they're accessing benefits?
I'm trying to remember. I want to say, and correct me if I'm wrong, Carrie, most of the time when they are conditional, I mean, there's a couple of different factors, not only their income, but they might not be eligible for many benefits. I mean, in the scenario that they are eligible for some benefits and they obtain them legally, then I don't know if maybe they still might be affected because, again, they don't have, I mean, they're still adjusting their status. Again, it's hard to answer some of these questions because we're going off of the 2-week drafts. And as we said earlier, they did change. One draft went from including some programs, and then the second draft excluded a program and added a new one.
At this point, I would be concerned because there will be some final adjustment process for that person. And I would be concerned that there wouldn't be a reason why the public charge test couldn't be applied at that final adjustment moment. But I don't have a definitive answer. But we can look and see if the immigration folks, I don't practice immigration law, I'm a public benefits wonk, if the immigration folks have a best guess on that. But certainly if you do not have conditional LPR status and you're married to a USC, then the test would absolutely be applied to you. But I will try, Bosh, to get an answer to that question.
Thank you. More questions from the group about where they can get more information in general.
So Luvia, I get the two agencies confused. It's milk.
Yeah. So at the national level, we're working with National Immigrant Law Center, NILC, as well as CLASS, Center for Law and Social Policy. They have some resources on their websites. We have resources on each of our relevant organizations' website as well. Depending what the resources are that you're looking for, happy to share with you. We have some fact sheets that go into the eligibility based by immigration status. So happy to share that. If you're looking into a fact sheet that has kind of all this information of the webinar, I'm sure that, that one of your colleagues could share it, the PIF Illinois fact sheet. And eventually, once you sign up to the PIF Illinois at povertylaw.org, you will be getting any updated information, etc.
Great. Thank you so much. We are coming up on time. I want to thank the presenters so much for your time and the helpful information, and we hope to hear from you again very soon on more information. And thank you all for participating actively in the call and for all the thoughtful questions that you have. Just to let you all know, we will be emailing out this recorded PowerPoint presentation, so you will have access to this information. And as always, if you have any questions not addressed today, please feel free to email me directly, Osunmakinde@aidchicago.org. Most of you should have my email, but feel free to reach out to us, and we'll be sending the PowerPoint presentation as well as other fact sheets that have been mentioned as part of this presentation. So thank you all, and I hope you have a good rest of your day.